In this video, you will learn about victim rights in Indiana. The General Victim Rights Amendment was added to the Indiana Constitution in 1995. These rights were expanded and detailed in the Indiana Code in 1996. These rights are important to victims, to law enforcement, to prosecutors, and to advocates alike, as they help guide equitable treatment of victims. Knowledge of this statute also helps educate victims on what their rights are in a criminal proceeding and what reasonable expectations are for their part in the process. Each right will be discussed in this video in more detail. There are no formal enforcement mechanisms for this statute. However, it can be interpreted as sworn law enforcement and prosecutors should exert their best effort to uphold these rights for victims. If you are concerned that your victim rights or the rights of a victim you are helping are not being upheld, please contact the supervisor for the agency in question.
First and foremost, victims have the right to be informed of their constitutional and statutory rights as a crime victim. Many police officers in Indiana provide a victim's rights card after completing a police report. Some prosecutors' offices provide a copy of these rights with their initial letter to the victim to inform them of upcoming court dates. All citizens can find a complete copy of these rights by looking up Indiana Code 35-40-5. If a victim does not have internet access, many libraries, police departments, and social service providers will be glad to provide a copy of the victim rights.
Victims have the right to be treated with fairness, dignity, and respect, and free from intimidation, harassment, and abuse throughout the criminal justice process. This may include communication and other interactions with law enforcement, prosecutors, judges, probation officers, or other agents of the criminal justice system. Victims should be spoken to and treated with respect and honesty. Many prosecutors utilize no contact orders to increase victim safety while a case is pending and after conviction. These orders provide protections and restrains the offender from contact with the victim. These orders may decrease the victim's exposure to harassment and abuse.
A victim has the right to confer with a representative of the prosecuting attorney's office after a crime has been charged, before the trial, and before any disposition of a criminal case involving the victim. This right applies automatically in the following situations: the alleged felony offenses committed against the victim, the alleged misdemeanor offenses committed against the victim, which includes the crimes of battery, domestic battery, aggravated battery, battery by body waste, criminal recklessness, intimidation, harassment, invasion of privacy, and pointing a firearm. It is important to remember that this right to confer does not include the authority to direct the prosecution of a criminal case. The prosecutor should discuss plea agreements and/or strategy with the victim, listen to and answer questions, but is not obligated to modify any proceedings based on victim wishes.
A victim has the right to make a written or oral statement for use in preparation of the pre-sentence report. The victim also has the right to read pre-sentence reports relating to the crime committed against the victim in order that the victim can respond to the pre-sentence report. Pre-sentence reports are often prepared by probation department staff. Victims are usually contacted to make a statement to include in the report if they choose to do so. The victim should speak with the prosecutor assigned to their case to review the completed pre-sentence report before the final sentencing hearing. This does not allow the victim to view parts of the report pertaining to other victims or confidential information. If the victim feels that any portion of the pre-sentence report is untrue, or if they were not consulted for a statement in the report, they can express this to the judge during their impact statement at sentencing.
A victim has the right to be heard at any proceeding involving sentence or post-conviction release decision. A victim's right to be heard may be exercised through an oral or written statement or submission of a statement through audio tape or videotape. It is important to note that a victim is not required to make an impact statement at sentencing, and while the judge must allow them to be heard if they choose, all sentencing decisions are ultimately made by the judge.
A victim has the right to be informed upon request when a person who is accused of committing or convicted of committing a crime is released from custody or has escaped. This includes release or escape from a mental health facility. For offenders in an Indiana County jail, victims may use the Victim Information and Notification Service, VINE. Indiana VINE is a service providing crime victims free, prompt, and confidential notification and status information for offenders in Indiana County jails. Information is provided 24 hours a day over the phone, through the internet, or by email. Victims may register through the VINE website or by calling 1-866-959-VINE. For offenders in the Indiana Department of Corrections, victims can utilize the SAVIN system. Indiana SAVIN stands for Statewide Automated Victim Information and Notification. This program is a free, automated hotline that provides crime victims with vital information and notification 24 hours a day, 365 days a year. Once again, victims can also register online for alerts through the Indiana Department of Corrections website or by calling SAVIN hotline at 866-891-0330. Please remember that while VINE and SAVIN are valuable tools, they are not 100% accurate. If a victim has concerns about an offender's release date, they should always err on the side of caution and take steps to increase safety and get more information from their local prosecutor's office.
A victim has the right to have their safety considered in determining release from custody of a person accused of committing a crime against the victim. The victim's safety should be considered by both the prosecutor and presiding judge. Safety concerns may be raised by the prosecutor through the entry of supporting evidence or through victim testimony directly. Please note that the prosecutor and judge are only obligated to consider victim safety in making decisions. They are not obligated to agree with the victim's wishes.
A victim has the right to information upon request about the deposition of the criminal case involving the victim or the conviction, sentence, and release of an offender. This information is provided by the county's prosecutor's office, but may be provided by local law enforcement and court staff. The victim only has a right to information that is public. They do not have the right to access confidential information or any documents protected by law or court decree.
Respect for and adherence to the Victims' Rights Statute is the responsibility of every judge, prosecutor, police officer, and advocate in our community. This piece of Indiana code emphasizes the importance of respectful, honest, and dignified treatment of crime victims, but it also sets up clear expectations for victims themselves.
When victim rights are executed properly, it can increase a victim's confidence in law enforcement and criminal justice proceedings, which may, in turn, increase both victim safety and offender accountability. When victims feel knowledgeable and secure, they are more likely to seek help. For all of you that serve victims that are scared, confused, or disenfranchised, we thank you for the role you play in serving victims. Your work is important, necessary, and often thankless. Victims of all crimes, past, present, and future, benefit from your selflessness and dedication to your work.
These victim rights are a natural extension of the hard work we all do every day. We fight for those without a voice. It only makes sense we want the same people to be treated with dignity. Thank you for watching this video and increasing the rights of crime victims in our community.